the D.C. Circuit Court of Appeals found 3-0 that he was not immune from criminal prosecution for acts he took.
Yeah. So can he appeal this? Or it does seem to have helped his cause to delay things as much as possible.
It certainly has done that, and he's almost certainly will appeal to the full Supreme Court. And how quickly they'll take that up is uncertain. And that postpones the federal trial on the charges of insurrection brought by Special Counsel Jack Smith.
Yeah.
So it's good that the decision came out in terms of moving the trial along, but there are further stages to go.
Indeed. All right, let's come to this Colorado case with the Supreme Court hearing arguments today surrounding his eligibility to be on the ballot. Take us through what's happened and what the arguments here are.
Okay, well, basically, as part of the 14th Amendment, there is Section 3. And the 14th Amendment, was enacted and ratified after the Civil War. And Section 3 prohibits anyone from holding, it's a little convoluted, anyone from holding federal public office, I'll just group the offices together that way, who has taken an oath to uphold the Constitution and then participated in an insurrection. And so voters, a variety of different people, have brought challenges all across the United States. 35 different states have challenges against Trump being on the ballot based on this provision that he participated in an insurrection. So the voters in Colorado brought a case in state district court in Colorado to disqualify him. And the trial court found that he had participated in an insurrection and that all of the other prohibitions of Section 3 were met, except that he was not an officer of the United States, as that term is used. That went up to the Colorado Supreme Court, and the Colorado Supreme Court reversed the part about the officer of the United States and essentially disqualified him from being on the Colorado ballot. Then they stayed their own opinion, assuming that he would take it to the United States Supreme Court, and that's exactly what he did, and that's what's being heard Thursday.
Yeah. So give us a sense of how the Supreme Court is going to go about hearing this argument. He, of course, says this rule doesn't apply to him. Will they be looking at that, or are they just looking at sort of the basics of law here?
Well, that's a great question. I think that the starting place for considering this is realizing that this part of the Constitution has not been litigated at all before. Well, I mean, there are a sprinkle of cases, but it hasn't been up at the United States Supreme Court. So there are, and if you look at the Colorado Supreme Court decision, it's over 100 pages long. There are multiple issues. So one of the issues they're going to look at is whether it applies to the presidency, but there are a vast number, okay, I'm saying vast, there are 5 or 6 other issues involved in the case. And there's this overarching issue about the effect on the separation of powers for the Supreme Court to sort of step in and take somebody out of the ballot who may be the preference of a sizable number of the American population.
And that is so fascinating because, of course, this is a highly conservative court. A third of this court was appointed by Trump. So what is your sense as to whether that's going to come into their considerations?
Well, notwithstanding that he appointed 3 of these justices, the court has not acted enormously in his favor on a variety of things. I mean, there have been cases where you would, if you expected a knee-jerk reaction from the 3 appointees, you did not get it. They have not been afraid to go against him, as it were. That said, it is a conservative court. And quite honestly, I think any court, any Supreme Court would tread very lightly in this situation. because of the anti-democratic effects it has, and also because it's going to be creating new law to begin with. So the sort of two steps of doing something to take out a candidate and doing it in the interpretation where they're not bound, it's not as though they're bound by precedent to have to go in that direction. I would be very, very surprised if they would uphold the Colorado decision.
Yeah. So, and then, Lynne, if they don't uphold the Colorado decision, does that kind of throw out the rest of the states that are considering similar action, taking him off the ballot?
It really depends on what they find. There's so much room for their decision to go in different directions that it's a little bit hard to predict what effect that would have on challenges elsewhere. It's a little easier to predict if they were to uphold it.
Yeah, it would be interesting. I know you probably wouldn't take on his cases, but if you were his lawyer, would you want him in court for the Supreme Court hearing?
Oh, what a fascinating question. No.
He hasn't helped himself in other cases, has he?
Right. You notice I didn't add a lot after the no. I was going to say something about he doesn't play in the sandbox well, but suffice it to say that's probably enough to say why I would say no.
Yeah, and then hope he'd listen to you, because he doesn't always do that either. To his lawyers.
There's that.
Yeah, there's that. Look, before we let you go, a really interesting case today with the mother of a 15-year-old boy who shot dead 4 of his classmates has been found guilty of manslaughter. What did you make of this case, and how concerned would you be that it could establish some form of precedent to hold parents responsible?
Well, it's new. I mean, this hasn't been done much. You know, I clerked for a judge once that told me that every case was about the facts. And so I'm not that worried that it would create a dangerous precedent, because the facts in this case are so incredibly egregious. It is extremely difficult to imagine a parent-child situation where they were more negligent, more reckless about dealing with a child. I mean, these parents, I believe they bought him the gun. And the failure to act when school officials, alerted them is just, it's pretty horrifying. So I think there's, reason to say this is precedent for going in a new path, but the facts are egregious enough that I'm not sure I worry about its abuse.
Yeah, that it would be repeated. Yeah, it was quite remarkable. And she said in court that she wouldn't do anything differently, which was also quite astounding to hear, really. Always good to have you, and thanks for getting up so early for us. Much appreciated.
I appreciate it. Thanks for having me.
Thanks, Lynne.